I'm one of the family law attorneys here at Jodat, and I'm going to talk with you today about equitable distribution. So equitable distribution is one of the major issues that comes along with filing for divorce. And the first issue when you're talking about equitable distribution is how to classify what it is we're actually talking about. So when we're talking about equitable distribution, we're talking about what assets and liabilities need to be divided between the parties. So the first question is going to be, well, what counts? So there's three different classifications. There's premarital, non-marital, and marital assets and liabilities. So premarital would be any assets or liabilities that either party came into the marriage with. So at the time that you got married, what did you have? So one common issue that comes up with a premarital classification is whether or not an asset has been commingled during the course of the marriage. So one common way that often comes up is with a piece of property. So maybe one spouse had a home prior to the marriage, and during the course of the marriage, they put the other party on the deed to the home. At that point, you're faced with whether or not that property has now become a marital asset subject to be divided, regardless of whether you had that home prior to the marriage. If you determine that something is a premarital asset or liability, that asset or liability does not get factored in for equitable distribution purposes. The second classification would be a non-marital asset or liability, and that would be one that during the course of the marriage was acquired. However, for some reason it is not considered to be marital, it's not subject to be divided between the parties. So that oftentimes would be, for example, an inheritance that one spouse received during the course of the marriage, or even a personal injury settlement could be considered the non-marital asset of one of the parties. Now that one is a little bit trickier because there are some pieces of a personal injury settlement that could be considered marital, lost wages, compensation for medical expenses, a loss of consortium claim. Those are all reasons that you can determine that a non-marital injury settlement actually be considered, at least a portion of it, to be marital. And the last classification would be marital assets and marital debts. And those are any assets or debts accumulated during the course of the marriage, no matter whose name they're in or whether they're joint or not. So marital assets and debts are obviously subject to be divided between the two parties. So the questions become when we're talking about the marital assets and debts is, when are we talking about? So we're talking about at the date someone files for divorce, what assets, what liabilities are in existence. And then the next question is going to be, well, how do we value those? So we know what's in existence, but how much of a debt is it? How much of an asset is it? And for that, the court generally looks at that same date of filing. So at the time of filing, what is the home worth? At the time of filing, how much was on the credit card? However, the court can look at an alternate date. So for example, if one party was willfully dissipating an asset, is that a way that we're going to look at maybe the higher value and not necessarily at the time of filing what that value was?